Ready, start. Learn Council for the appellant has submitted that while awarding the compensation, tribunal committed an illegal in making only one-fourth deduction towards personal and living expenses of the decrease and not to be making deduction the amount of family pension. Learn Council further submitted that from the FIR it is established that accident in questions was a result of head-on collision of bus and motorcycle. Hence, in any case, the liability for making payment of compensation ought to have been apportionate, but the tribunal committed an illegal in not consider the same. The Learn Council further submitted that compensation awarded by the tribunal is excessive and examine the award therefore is liable to be modified. Para. Per contra, Learn Council for the respondent claimants has submitted that it is proved from the oral and documentary evidence adduced by the respondent claimant that accident in question had occurred on account of rash and negligent driving of the driver of the said offending bus. Deceased was not responsible for the accident in question. Learn Council further submitted that impugnate judgment and award passed by the tribunal is just and reasonable and therefore does not require any interference by this court. As such, this appeal is liable to be dismissed. Learn Council for the claimant respondents has further submitted that the matter in respect of permission to file the appeal under section 170 of the Motor Vehicle Act has been referred to the larger bench. He further submits that once the reference has been made to the larger bench, the question of obtaining the permission under section 170 of the Act is mandatory upon the applicant insurance company. If permission has not been granted, then the objection can be raised only on limited ground in regard to questionnaires. Para, we have examined the argument of Learn Council for the claimant's respondent and we find that points 3 to 5 have been referred to the larger bench, but they do not deal with the issue where the insurance company has been implicated as a party and has contended the claim before the tribunal. If the insurance company has been implicated as a party and had contested the claim before the tribunal, then the issue has been referred to the larger bench is not attracted. The present case is covered under para 8 of the aforesaid judgment, wherein the contingency has been dealt with, and therefore the argument of Learn Council for the claimant respondent that the matter has been referred to the larger bench in regard to obtaining the permission under section 170 of the Act does not hold good and the parties are to be governed by the finding records in para 8 of the judgment, which has become final and the same has been recorded in respect of point 1 and draw as the compared to point 3 to 5 where the insurance company has not put in the appearance and had not consented the claim. It is therefore to mention here that the FIR and filing of the charge sheet against the driver of the said offending bus are not in disputes. Full stop.